Alright, welcome to my YouTube channel. If you are meeting me for the first time, this is Counsel for the Rich Only. Do not forget the name. So today we'll be looking at infants. Yes, we talked about illiterates under capacity to contract. Remember, we are still looking at the elements of contract, and we've done, of course, offer, acceptance, consideration, intention to enter legal relations. Now, this one we are looking at capacity. And we have done illiterates under capacity. Now today we'll be looking at infants, lunatics, and drunkards, so that we will conclude capacity and enter into the next topic. We have tried in these elements of contract. And if after we are done with these elements of contract and you still do not understand anything on elements of contract, I am available for you to ask me any question that you want to ask me, yeah, on elements of contract. But let us continue with infants, because that's where we stopped. That was where we stopped in the last class. Now, capacity, of course, like I told you in reflection of your memory, we're looking at the qualifications. We're looking at whether you want to enter into this contract, you are qualified. And I told you that everybody is seen as qualified unless you can show that this person is not qualified. And when I mean that this person is not qualified, for people that you might think, or you might assume, or you might say that they fall under the category of these people that are not qualified, the law protects them, and the law usually protects them so that you would not cheat them, so that you are actually qualified to enter into that contract, will not cheat them. And we mentioned the categories of these people. We said illiterates, we say the infants, we say drunkards, we say lunatics, because these people are the people that when they go into a contract without the law's protection, the people will find it very easy to deceive them, and they will regret entering into the contract. So the law is there to protect these people, and it is extremely important, because if the law is not there, people will cheat them a whole lot. These are people that are prone to be cheated, so the law is guiding them. So today we'll be looking at the infants. Of course, infants generally are gullible people. So when I'm talking about infants, I'm saying like the real infants, the ones we know as infants, biologically speaking. When we say infants, we're talking about babies. Yeah, babies are very gullible, and so it's going to be somehow, if you leave that baby to actually fend for himself, of course it's not going to be possible, safe not to talk of him being somehow. So that is the idea here. Infants under the law still treats them as the infants we know. The law sees them as very gullible people, so that you will not come and now say that you're entering into any contract with them and now cheat them. That is why we want to learn, how does the law protect these infants? Now, first of all, we look at who is an infant. The first one here, we look at who is an infant. And the case we'll be looking at, and the case that will be our locus classicus, if you want to answer any question that relates to who an infant is. If you want to answer any question, the authority that you'll be using is the case of Labenjo against Abake. Labenjo against Abake. And in that case, to cut the whole long story short, because I wouldn't want this video to be very long, so that you would watch it. Yeah, you watch it to the end. To cut the whole long story short, Labenjo and Abake is saying that contractual age is 21 years, as according to Infant Relief Act of 1874. We are using the Infant Relief Act of 1874. So even if you don't remember Labenjo against Abake, remember Infant Relief Act of 1874. Because your principles must have to come with authorities. Any principle of law you are bringing out, you must have to state authorities that you are citing. If it is not law, as in sections of law or sections of provisions of the law, you are talking about cases, locus classicus, cases that expressed some kind of principles that you are trying to assert in your exam hall, or maybe generally as you are progressing in your arguments as a law student or as a lawyer. Labenjo against Abake is an authority that 21 years is the year of majority. So that means when you are below 21 years, you are under the category of infants as relates contract. So people that are watching me, I know most of you are in year 2 and some of you have not reached 21 years. So I'm talking to you people. You people are still infants. So don't be saying, I'm above 18. Yes, 18, above 18 is, of course, adulthood or majority in other parts of the law. But we're talking about contract. And under contract, if you're under 21 years, you're not an adult. You've not reached the contractual age. So we are using 21 as the infant, as the majority age, of course, below 21. So if you're 20 and you're watching me, Just know that you are an infant. If you are 18, if you are 19, know you are an infant. And everything we'll be talking about in the contract, in law of contract, pertains to you. So you will now know how to enter contracts and the kinds of contract that you are not allowed to enter and the kinds of contract that you are allowed to enter. So what is the position at common law? Position at common law is that contracts entered into by infants are voidable at their option. So you are a 20-year-old, you are watching me now. Contract entered into by you is voidable at your option. And I mean, these contracts, under common law, they are not binding on you, but they are binding on the other person. As far as that person is an adult. So I enter into a contract with you. You are an infant. It is not binding on you. I can't sue you to recover maybe consideration or something. But you can sue me to recover consideration. So it is binding on me that I'm an adult, but it is not binding on you. That's the position of common law. And under common law, contracts were classified into two groups. Now listen and listen attentively. This is where the technicalities now come in. So if you are not listening, you will miss it. So we are still looking at the position at common law. Contracts with infants. I mean, what does common law say, or what did common law say? After that, we'll go into statutory intervention, because statutes now came and intervened, and we now moved away from what the common law was saying. But before we learn what is obtainable now based on the statutory intervention, we have to learn first of all what was in existence. And that is under common law. And under common law, I was saying that contracts with infants, they are classified into two groups. Number one is contracts which are binding on the infant until it is being repudiated by the infant. Probably he repudiates that contract when he's still an infant, or within a reasonable time after he must have attained adulthood or majority. I'll take it again. Number one group of these contracts under the common law, under the position of common law, contracts that are binding on the infant until the infant repudiates the contract. And this repudiation can be done either as an infant, still under the confines of the age I talked about, till under 21, or a reasonable time after he must have attained at majority, that is 21 years. So if he repudiates a contract, depending on what reasonable time is, because nobody measures reasonable time except the court, it's the court that will tell you that this is reasonable time. So if he's able to repudiate the contract, maybe immediately he enters 21 years or maybe 22 years, it can be taken as reasonable time. So repudiating a contract means running away from the obligation, like saying, no, I'm not doing it again, without any problem. So it is binding on him, first of all, until he repudiates the contract. And he can repudiate that as an infant or after he must have attained majority. You see how many times I've said this thing? It's so that you will learn it and know it. Number two group is contracts that are not binding on him, but when he now attains majority, he now ratifies them. Do you understand? So normally this contract is not binding on him as an infant, but now he has attained majority, he has reached 21 years, so he can now ratify this contract. Ratify means he can now say, okay, I have approved of this contract. Let us continue. Before it was not binding. When he now attains majority and he ratifies it, it becomes binding on him. So I've talked about the two groups under the common law that the contracts are divided. Two categories that contracts are being divided under the common law. Number one is contracts that are binding on the infant until it is being repudiated by the infant. And that repudiation can happen when the infant is still an infant, at infancy, or within reasonable time after he must have attained majority. That is one group. Number two group is that contracts that are not binding ab initio. It was not binding, of course, on the infant. But when the infant has attained majority, he can now ratify this contract. So these are two categories of contracts, two groups of contracts under the common law, based on contracts with infants. So when we are talking about contracts with infants, we've looked at the two groups under the common law that the common law divided the contracts with infants. So the contract with infants comes under these two categories under the position at common law. Now we'll look at statutory intervention. Of course, you know what statutory is. Statutes means written laws. If you don't know, you cannot be in 200 level and not know what statutes mean. But I've said it, of course. So we're now looking at what statutes came into place to modify the provisions of the common law. So, Infant Relief Act of 1874. Don't forget this act. Don't forget this act though. The Infant Relief Act now came in and made some modifications. Number one modification is made is that it declared void some kind of contracts you can enter with an infant. So there are some categories of contracts you cannot enter with an infant. In fact, if you even enter that contract with an infant, there is no contract that is existing. That is, it is void. So your void is different from voidable. Void means from the beginning it is not, you are not even into any contract. Voidable is that yes, you're into a contract, but at my instance I can say let it spoil and it will spoil. I'm not doing it again, or you cannot do anything about it. As far as I've said, let it spoil or let it be void, it will now be void. But void, I don't need to say let it now be void. It has already been void since. So these contracts are void ab initio, and these are the categories of this contract that the statutory intervention has come. The statute has come in to say these categories of contract, if you enter it with an infant, you are playing because it is void. And number one is contract of loans. You cannot enter into a contract of loan with an infant. In fact, let me even tell you, if you enter into contract of loans with an infant and you give the infant loan, the infant can carry the money and go and not give you back. And you cannot sue the infant. In fact, if you sue the infant raises only the defense of, see, I am an infant. And the court will say, under the Infant Relief Act, the contract to enter loan agreement or loan contract with an infant is void ab initio. And so it is as good as you did not enter into any contract. So go home and go and cry. So that is it. Number one is loan agreement with an infant. Number two is selling goods to an infant that are not necessaries. So of course, you know, infants can enter into contract of necessaries. Now, the ones that are void is that you are selling a good or you are entering into a contract as regards goods other than necessaries. So if they check it and it is not necessaries, then you're on your own because it is void contract ab initio. Number three, account stated. That is how it's written in the law, account stated. But you would see it like that and you might be confused. But in treaty on contract, it defined account stated as admission to debt, D-E-B-T. So B is actually silent, so I have to spell it so that you don't think I'm talking about, you understand? So admission to debt. So even if we do not enter into a contract, you know, and I admit that I am owing you, maybe because I broke your favorite plate, I say I'll pay you, that is account stated. And so even account stated, yeah, it cannot be enforceable against the infant because it is void. So I've mentioned 3 void contracts. You should not even try to enter with an infant, which means if you enter into that with an infant, it is void. Number 1 is loan, for loan. Number 2 is goods other than necessaries. Number 3 is account stated. Take these 3 as void. You might see it in your exam. They have borrowed money to Nkechi that was 20 years old and he has blah 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 blah. Advise the parties. These are void contracts under the Infant Relief Act of 1874. They've sold one kind of fridge and it's not necessary and blah blah blah. Advice, and it is an infant they sold the fridge to. Goods other than necessaries are not binding. In fact, they are void. I know I'm telling you, I'm repeating myself because people say contract is technical. It is not technical, it's just that you don't like to listen. So listen. So another thing the statutes came to modify in the position as common law. Remember I said that contracts that are not binding on the infant can be ratified by the infant upon attainment of majority. However, the Infant Relief Act, the statutory intervention, is saying that that one cannot be possible again. Yes, because you cannot say that you are ratifying a contract when you have attained majority. In fact, it was removed. They expressly said, no, it cannot happen. So when you're talking about ratifying, under the statutory intervention, it was not there. But under the position as common law, it was there. So the statutory intervention came in to modify it in such a way that infants ratifying a contract that they entered upon attainment of majority, that is upon reaching 21 years, is no longer the law under the Infants Relief Act of 1874. Okay, we'll go into liability for necessaries. So what you need to know there, just important points. An infant is expected to pay reasonable price for necessaries. Now you ask me, what's the meaning of reasonable price? My brother, reasonable price is relative. So you don't expect an infant to pay you don't expect an infant to pay the actual price, yeah, or the contractual price. The price they will pay is what the law calls reasonable price. And so reasonable price or reasonability of price or reasonableness of price is a question of fact and not of law. Now you might ask, what's the meaning of necessaries? What's the meaning of necessaries? Now, permit me to read for you. But I will not finish the reading because it's too much quotation. Alderson B, in the case of Chapel against Cooper. Now you must have to go and read this definition. Because you cannot be explaining the meaning of necessaries without giving this as an authority. Contract has a lot of cases and a lot of authorities that you must know before your exams. Okay. So under Alderson B in Chapel against Cooper says this. It says things necessary are those without which an individual cannot reasonably exist. If I read, I'll explain. So what can you not reasonably exist if it is not there? That is necessary. Of course, you know your food, shelter, you get. So these are necessaries, and these are the things that as an infant, you can enter into a contract of necessaries. And of course, you're expected to pay reasonable price. Don't forget that reasonable price, because I like it too much. It means that means you don't have to pay the actual price. Just pay reasonable price, something that is reasonable to you. Finish. Infants are enjoying so much. That is if you have the knowledge of the law, just like you have, or just like you're having. Okay. In the first place, food, raiment, lodging, and the like. About these, there is no doubt, of course. Again, as the proper cultivation of the mind is as expedient as the support of the body, instruction in art or trade, or intellectual, moral, and religious information may be a necessary. So this one is now saying that apart from the food and the clothing and the lodging, when you are talking about teaching, learning a skill, learning in school, it is also necessary because, of course, it is increasing your mind. And so he equated the emancipation of the mind, or what we call, or learning of skill and learning of all these things as, he equated it with the support of the body. And so he categorized it under necessaries. So that means you can enter into a contract of course, apprenticeship. You can enter into a contract of schooling. You can actually be the person entering into the contract with the school, where you actually, take control of the contract, not just your parents. So that is a necessary. Again, as man lives in society, the assistance and attendance of others may be a necessary to his well-being. Hence, attendance may vary according to the state and condition of the infant himself. Yeah? So, socially, there are people coming to see you. When you say attendance, people coming to visit you. That's what I understand by it. Attendance. It says, as man lives in society, the assistance and attendance of others may be necessary to his well-being. So it is important that people care about you. Yeah, so that is a necessary. I don't know how you can enter into a contract with somebody to care for you. No, but of course, this was categorized under necessaries. Okay, so you can just read it. Okay, I'll just read the last line. It says, thus, articles of mere luxury are always excluded, though luxurious articles of utility are in some cases allowed. So most of the times, luxuries, yeah, you want to wear a Rolex watch, you want to wear that, those ones are not necessaries. Especially maybe if they look at your status and you see that, okay, you're not supposed to even wear a Rolex watch because you've not eaten since in the morning. So you want to go and enter into the contract of wearing Rolex watch so that when they come, you tell them that you're an infant. No, that one will not work for you. I know you people are now planning some things in your head. It will not work. Of course, I talked about loans for necessary. So even if it is necessary, you want to go and buy, you want to go and take loan. Loans are void. An infant cannot take loan. It is void. If you now go and enter into the contract with the infant, it is void ab initio. However, when an infant takes a loan, listen. When an infant takes a loan, and you cannot, of course, you cannot recover the loan from the infant, But you can now apply the doctrine of subrogation. The doctrine of what? Subrogation. Now, what is subrogation? I wanted to give it to you as an assignment, but let me tell you. Subrogation is kind of when you substitute a person that is supposed to be liable to you with another person. So let us say the infant has collected the loan and has bought something. So that person he bought that thing from, you can't, with the doctrine of subrogation, substitute the liability of the infant with that person that he bought something, and you can now recover your loan from the person that he bought something from. So that's the doctrine of subrogation. Stay go and read about it. So apprenticeship and other beneficial contract. Of course, we talked about that when I was reading the meaning of necessaries. And so the base thing you need to know there is in apprenticeship and other beneficial services, the advantage must be to the infant. Of course, if the advantage is not to the infant, or if the infant does not enjoy much advantages, then it cannot work. So apprenticeship, of course, the infant can enter into the contract of apprenticeship and other beneficial services, and it will be binding on him, because that is, of course, part or category of necessaries, and it comes under the category of contracts that the infant will enter that will be binding on him. So that is that about that. And remember that necessaries are expected to be, how do I put this? Necessaries are expected to still be important or necessary as at the time that you are trying to deliver it to the person, to the infant. What do I mean? If the infant has told you, see, I need bread, yeah, it is necessary at that time. But as he just dropped the call, his friend came in with bread to give him, and he's eating it. He doesn't need that bread that he called you to place an order for again. And so when you bring it, you can say, no, sorry, I can't take this bread that you brought. And you cannot do anything about it, because the law says that the necessary must still be, if it's not necessary again, why do we call it necessary? Fraudulent misrepresentation of age. Now, what does this mean? So someone that's not up to 21 has lied to you that, see, I'm up to 21 or 22 so that you can enter into this contract with me. Let me tell you, even if he lied, you will not still do anything. But of course, that is in law, that is the actual law. But in equity, you can do something. And under the equity, we are looking at the doctrine of restitution. So you need to put back the person that you have deceived in the position he was before he entered into that contract with you, based on your fraudulent misrepresentation. But it's not in all circumstances. There are some circumstances which I will be telling you now. Number one, if the infant obtains goods by fraud and remains in possession, the infant can be made to return those goods. So based on this fraudulent misrepresentation of age, or fraudulently he obtains goods and he's still in possession of it, he is still in possession. Now let me explain this. And I'm talking about the circumstances where fraudulent misrepresentation of age can make you recover something from the infant, because ordinarily you cannot. But there are some circumstances where the equity or the equitable doctrine of restitution can come in, and these are the circumstances that I'm telling you. Number one, when he fraudulently collects goods from you and he is still in possession of it, what does this mean? It means that those particular goods are the ones that he collected from you, and he's still with it, and you can prove that those ones are the actual ones he collected. It is not by substitution. So let us say he collected the goods from me and he has sold them and he bought another goods, and you're telling me that you want to go and recover the goods he bought. No, it doesn't work like that. What he's saying is that the goods, if it is this particular marker he collected from you fraudulently, what you can recover from him is this same exact marker, not another blue marker. No, this particular one. So that is it. So this one is the one you can collect back. But you cannot say, okay, you are recovering the money valued, that this marker is valued for. No, you must collect exactly this. And if you have sold it, that is your problem. You go back and cry. So if you have sold the goods, of course, there's nothing you can do. But there is a particular, of course, there are contrary views. Read the case of Leslie Limited versus Shell. Now, the contrary case is Stocks versus Wilson. So read the two cases, and there are contrary views to when the goods that he originally took from you has been sold, whether you can recover money. One party say you cannot, because when you're talking about repayment is different from restitution. Yeah, the other party saying yes, you can actually recover the money. So read the cases and know what you think. Now, another time that you can recover something from the infant, just like in the property that we talked about, the first one, if he obtains money from you, cash, you can recover that cash you collected from you, just like in the property we talked about. It must be that it's that same cash. How do I put this? I don't have any money with me. That particular money, not another money. I don't know if you understand me. So he collected 50,000 naira from you. Yes, those 50, that exact money is one you can recover from him. If he has spent that one, there's nothing you can do. So it must be that particular money. That particular money, that one, that exact. Because we are talking about restitution, not repayment. Restitution. So it must be that one. So that is when you can recover, when he fraudulently collects the money from you and all that. So let us go ahead to look at drunkards, lunatics. So the contracts under lunatic can be classified into two. Contracts of necessaries, you've seen necessaries again, and contracts of other things. If the goods are not necessaries, yeah, listen, it's different from infants, yeah. If the goods are not necessaries, the lunatic can be bound. In fact, is bound by the contract. That is, if it is not necessary. If the goods are not necessaries now, the lunatics are bound by the contract. Unless he can show that, number one, owing to his mental disorder, he never understood what was going on at the time the contract was being entered into. And number two, that the other person knew of his mental disorder and entered into the contract with him. That is when it will not be binding on him. So I am saying, general rule, lunatics are bound by contracts they entered, even though it is not necessary, even though it's not contract of necessaries. But the only time they will not be bound is when they can show that, number one, owing to their mental capacity, they were not themselves, they did not understand what was going on. And number two, the other party that they entered into that contract with knew their mental disorder, knew about the mental disorder, and still entered into the contract with them. If he can show these two elements, then the contract will not be binding on him. And it is important I tell you that even if he shows those two elements, it does not make the contract void. However, it makes the contract voidable. Voidable at his option. That is the lunatic's option. Why am I doing like this when I say lunatic? I beg you, God forbid, go like this. At the lunatic's option. Voidable, not void. Voidable, not void. So you know the effect. Of course, it is expected that you know by now that lunatics can enter into contracts when in their lucid moment. So sometimes that they are okay, they can enter into contract. Of course, when they understand that, okay, I'm entering into a contract. Yeah, so they can enter into a contract even at lucid moment. So we're going to drunkenness, drunk people. Drunk people also, it applies, this particular principle I said, it applies. A drunk person, a drunk, can enter into a contract and the contract will be binding on him unless he can show that as at the time he entered into that contract, he was drunk, he did not know what was happening, and the other person knew that he was drunk and still entered into contract with him. So it's a little bit the same. The drunkard can still ratify a contract that he has entered once the drink clears off his eye. Yes. So as regards necessaries, both the infant, the drunkard, the lunatic, they're expected to, of course, pay a reasonable price, which we've talked about. So this brings us to the end of elements of contract. I am happy you stay to the end if you are still here. If you are still here, I'm happy you stay to the end. Please do not take my videos as your conclusive study for exams. Still go and read your books. My video is just to explain to you what you must have read. So when you read before watching my videos, you will flow well with your understanding. And when you even watch my videos before reading, you will still flow well. But don't do one and leave one. Okay. Yeah, don't do one and leave one. If you read, please watch my video. Watch my video so that you have sense. All right. So, but don't go and watch my video alone and leave reading. You're on your long thing. So thank you very much. When next I come, we'll go to the next topic. Peace.